Hey guys, welcome back. This video is about some legal cases, in case you're wondering what kind of stuff you'll be studying in law school. I'm going to cover 10 legal cases that are mentioned in the book Getting to Maybe, which is a book that's supposed to help you to prepare for the law school exams. So let's go ahead and dive in. I'm going to cover quickly 10 legal cases and what they're about and their significance. Number one is Dickinson versus Dodds. In this case, Mr. Dodds delivered Mr. Dickinson an offer to sell a house for 800 euros, and an offer was open until 9 a.m. on Friday, June 12th. And then on Thursday afternoon, another man called Mr. Berry told Mr. Dickinson that the house had already been sold to someone called Mr. Allen. Mr. Allen, who was the second defendant, Mr. Dickinson found Mr. Dodds in the railway carriage at 7 a.m. on Friday morning, leaving the station, and gave his acceptance of the deal there. But Mr. Dodds said, "You're too late." And then Mr. Dickinson sued for breach of contract. The summary of the case was that communication of the withdrawal of an offer can be made by any reliable third party. So in this case, he was already informed that it had been sold to someone else by a third party, so therefore he could not sue for breach of contract. Number two case is Pearson versus Post. In this case, Lodowick Post, a fox hunter, was chasing a fox through a vacant lot when Pearson came across the fox, and knowing it was being chased by another, killed the fox and took it away, stealing his hunt. Post sued Pearson on an action for trespass on the case for damages against his possession of the fox. Post argued that he had ownership of the fox, as giving chase to an animal in the course of hunting it was sufficient to establish possession. The trial court found in favor of Post. On appeal, after the trial, the issue was put to the Supreme Court of Judicature of New York. And the question was whether one could obtain property rights to a wild animal, in this case the fox, solely by pursuit. The court reasoned that given the common law requirement to have control over one's possessions, merely giving chase was not sufficient. Something more was needed, otherwise law would create a slippery slope. So in this case, simply pursuing a fox was not enough. You had to actually kill the fox and take it. And this law is important in more than just the realm of hunting animals. It has repercussions in many different areas like real estate and other things. Pursuit of something is not necessarily signify ownership. The number three case is Planned Parenthood versus Casey. In this case, 1992, it was a landmark United States Supreme Court case in which the constitutionality of several Pennsylvania state statutory provisions regarding abortion were challenged. The court's plurality opinion reaffirmed the central holding of Roe v. Wade, stating that matters involving the most intimate and personal choices that people will make in their lifetime, choices central to personal dignity and autonomy, are central to the liberty protected by the 14th Amendment. The court's plurality opinion upheld the constitutional right to have an abortion, while altering the standard for analyzing restrictions on that right, crafting the undue burden standard for abortion restrictions. Planned Parenthood v. Casey differs from Roe v. Wade, however, because under Roe, the state could not regulate abortions in the first trimester, whereas under Planned Parenthood v. Casey, the state can regulate abortions in the first trimester of pregnancy, or any point before the point of viability, and beyond, as long as the regulation does not pose an undue burden on women's fundamental right to an abortion. Applying this new standard of review, the court upheld 4 regulations and invalidated the requirement of spousal notification. So it's no longer required after this for a woman to notify the father of the abortion. She can do it simply autonomously. The fourth case is Johnson versus Davis. Johnson, the defendant, agreed to sell his house to the Davises, the plaintiffs, but did not tell them what he knew about the poor structure of the roof. Miss Davis specifically asked about watermarks on the ceiling, but Johnson told her that they were not watermarks and that the roof was in good working order. After the Davises paid a deposit to Johnson for the house, a rainstorm occurred, and Mr. Davis entered the house to find water gushing in from the window and from the roof. The Davises brought suit alleging breach of contract and fraudulent misrepresentation. Johnson, the defendant, agreed to sell his house to the Davises, but did not tell them what he knew about the poor structure of the roof. Miss Davis specifically asked about watermarks on the ceiling, but Johnson told her they were not watermarks and that the roof was in good working order. After they paid a deposit for the house, a rainstorm occurred, and they found this destruction going on. The Davises the summary of this case is that holding that sellers, whether of new or used homes, have a duty to disclose to the buyers facts materially affecting the value of the property which are not readily observable. So after this case, it was decided that if you're selling something and you know there's a problem with it, you have to tell the buyer about that problem. Otherwise, you can be sued for breach of contract. Alright, the fifth case is Reynolds versus United States. This was a Supreme Court of the United States case that held that religious duty was not a defense to criminal indictment. Reynolds was the first Supreme Court opinion to address the impartial jury and the Confrontation Clause of the Sixth Amendment. Reynolds was a member of the Church of Jesus Christ Latter-day Saints, or the LDS Church, charged with bigamy under the Moral Anti-Bigamy Act after marrying Amelia Jane Schofield while still married to Mary Ann Tuddenham in Utah Territory. He was secretary to Brigham Young and presented himself as a test of the federal government's attempt to outlaw polygamy. An earlier conviction was overturned on technical grounds. The court summary is they affirmed Reynolds' conviction, making having multiple wives illegal in the United States, even if you are of a religion that respects that. It's still illegal in the United States to have multiple wives or to be a polygamist. The sixth case, Bowers versus Hardwick. After being charged with violating the Georgia statute criminalizing sodomy, by committing that act with another adult male in the bedroom of his home, respondent Hardwick brought suit in federal district court, challenging the constitutionality of the statute insofar as it criminalized consensual sodomy. The court granted the defendant's motion to dismiss for failure to state a claim. The Court of Appeals reversed and remanded, holding that the Georgia statute violated this respondent's fundamental rights, thereby making it illegal for states to have anti-sodomy laws in cases of consensual sodomy inside one's own home. The seventh case is Griswold versus Connecticut. In 1879, the state of Connecticut passed a law that prohibited any drug, medicinal,